question out there.
My Lord, over lunch I've been considering the answer to the point your Lordship put to me about the 3-year tenant. And my Lord, can I deal first with the position under section 161? I accept this. I accept that the bona fide purchaser's certificate of title is subject to the 3-year tenancy by virtue of the proviso in section 70. Therefore, if, let's say, the bona fide purchaser wrongfully kicked out the 3-year tenant, and the tenant then brought an action for recovery of the land under section 161, the purchaser would no doubt hold up his certificate in answer, saying, look, I'm the registered proprietor, to which the tenant could then say, no, but your certificate is deemed to be subject to the encumbrance of my 3-year tenancy. And in those circumstances, the tenant would be able to bring an action in damages against the bona fide purchaser.
But if that's right, then it must follow, mustn't it, that given that the tenant, 3-year tenant, relies on the proviso to section 70, that logically, surely, the same should apply to anyone else for them.
I was going to come to that, if I may, my Lord.
Assumed you
and my Lord, as it were, just dealing with the tenant for the 3-year tenant,
yes.
The bona fide purchaser would be in no better position against the 3-year tenant who was not noted on the register,
right,
than he would be against, let's say, a long lease, a 10-year tenant who was noted on the certificate. So he'd be in the same position in both cases. So the 3-year tenant is treated as if he's on the register, as if he's on the certificate, and therefore he has no defence to an action in damages or for ejectment. Now, what about the adverse possessor? Now, my Lord, my answer to that is this. It all comes back to the question whether Section 70 trumps Section 68 or the other way round. If I'm right in saying that you must read Section, as I submit I am, that you must read Section 70 as doing no more than referring back to the specifically limited rights in Section 68, if that is right, in other words, you don't read, it's a savings provision, but intended only to save what you see in Section 68, then the adverse possessor, by definition, acquires the only rights he ever has are against the, as it were, the vendor. He is not taken to have any rights against the bona fide purchaser for value. Therefore, to extend the example to the bona fide purchaser for value, when the bona fide purchaser for value kicks out, let's say, the adverse possessor tries to bring a claim in ejectment, then to which the bona fide purchaser says, look at my certificate of title. No doubt the adverse possessor says, but look at Section 70, to which the bona fide purchaser says, no, but Section 70 is subject to Section 68. The only rights you ever acquired as adverse possessor were against the vendor. You never acquired, but by virtue of Section 68, you acquired no rights as against me as the bona fide purchaser for value.
Does this mean that Section 161 drops out of the picture, really?
No, because in that situation, my Lord, Section 161 becomes the dominant provision, because what the bona fide purchaser says is you cannot bring yourself within Section 161E. You've got to bring yourself within Section 161E, and you can't do that because you're not a transferee. I'm a transferee for value.
I see. So you still need to say this is misdescription.
Yes, or wrong description of parcels, yes.
But Section 68, of course, isn't confined to the bona fide transferee for value, is it? I mean, on your reading of Section 68, then once there has been a transfer and there's a new certificate, time has to run against that transferee, be he gratuitous or be he for value.
No, my Lord, I don't, if I may say respectfully, I don't adopt that position. The position we adopt is that Section 68 is premised on there being a bona fide purchaser for value.
Oh, of course.
I
remember it from your case, that's fine.
And the reason I say that is, first of all, there's no exception for fraud, and that is very striking. I submit, why is there no exception for fraud in Section 68? I say that the presumption in Section 68 is talking about a situation where there has, by definition, been no fraud. Now, that, of course, doesn't necessarily mean that we're talking about a bona fide purchaser for value as such. But in my submission, that is the right approach. And there is a Supreme Court of Canada decision, I'm anxious about the time, it's at tab 27 of the authorities bundle, called F. Fred Cup, where they deal with very similar provisions as one sees in this statute, not identical, where they say the reconciliation, and the proper construction to give to the conclusive evidence provision is to treat that as replying only to certificates issued pursuant to a bona fide purchase for value. And, my lords, if I can just give you the reference, it's volume 3, tab 27, and this was a case where there were a series of transfers not for value, which excluded certain minerals. However, the actual certificate didn't refer to the exclusion, and the appellant said, oh, well, we've got a certificate which doesn't refer to the exclusion for certain minerals. Look, we've got these certificates. But the answer was, well, hang on, you're just mere bare transferees. And the Supreme Court considers this, essentially this argument. One can take it fairly quickly. Page 15 begins at 1518. The passage begins at 1518 in the judgment of Mr. Justice Martland at the top, when he's talking about, in the second paragraph, I turn now to sections 42, 44 and 104 of the Act, and if you turn back to 1512, you can see what he's talking about. 42 is not so important, but there's 44 and 104 are really the crucial provisions. 42 is lands up not being important. Really what is important is 44, which is a conclusive evidence provision attaching to a certificate of title. And then 104 is the same as section 161 in material respects.
So 44 is except in case of fraud. Is there such an exception in relation to section 68?
No. Sorry, 42 is except in the case of fraud, I think, my lord.
No, 44.
44.
44 is?
Yes.
Except in case of fraud.
I'm sorry, my lords, yes. But it's also a conclusive evidence provision. My lords, the real point I'm on is about this is a conclusive evidence provision. And then section 104.
So do you say that in section 68 it's conclusive even if it's fraudulent? In our section, in section 68?
Yes, my lords, I say section 44 is, on the face of it, my lords, doesn't refer at all to a bona fide purchase for value.
I know, but I'm just asking whether you say section 68 even applies where fraud arises.
My lords, I submit it couldn't apply where fraud. It's presupposing that there is no fraud, but inevitably.
So although not stated, that is implied?
Yes, it has to be, because otherwise, section 68 cannot mean literally what it says.
Well, yes, exactly.
But on the point you're trying to get from this
Yes.
case, where do we find it?
The actual point, it begins at page 1518, but which is a reference back to a previous judgment, but then 1519 is the court's conclusion about the certificate of title referred to in section 44. And the point,
Benefit only of bona fide purchaser.
yeah, and you've got to look at the scheme of the Act. In other words, this says you don't read, as it were, a conclusive evidence provision, such as you find in section 68, as literally meaning what it appears to say. That can't be right, because it would otherwise, for instance, in this case, it would allow the certificate to be held up, even if there has been a fraud. I mean, obviously, section 68 is not saying that. And you read section 68, the conclusive evidence provision, you read as subject to, or in the light of, rather, all the other provisions which give protection to the bona fide purchaser for value, and not in light of provisions which aren't talking about the bona fide purchaser for value. And that's the explanation of it. Now, my lords, I accept that. I just say, I give this by way of example. Of course, it's a different statute. But it is quite striking when you look at section 100, if you look at page 1519 of this judgment, it does have some pretty similar provisions to the ones that we're looking at in this case. And 106...
This is simply conclusive evidence in court, is that right?
Yes, conclusive evidence in court. And that's what section 68 in my submission is. It's conclusive evidence in court. The question is, in what circumstances?
And is there provision for rectification where there are mistakes in a certificate? Are there provisions for that?
There would be separate provisions.
Are there provisions for that in the Act? For corrections for misstatements and so on?
But I think there are slip rules.
Yeah, well then, surely it has to be read as subject to those. Does it not?
My Lord, yes, it would have to be read as subject to, well, of course,
What it's saying is that this is conclusive evidence.
yes.
But again, you come back to the fact it's conclusive evidence of what Section 70 says you get.
Well, it doesn't use the phrase, with respect, it doesn't use the phrase conclusive evidence. My Lord, perhaps I just...
It does use the expression conclusive evidence.
Sorry, Section 70.
768 does.
Oh, 68, certainly.
It's conclusive evidence that it has the estate, but in order to see what the estate is, you look at Section 70.
Yes,
It brings you back to the point.
well, but my Lord, what it also says in Section 68, can I just briefly summarise why I say Section 68 wins in a few words.
Yes,
First,
of course.
it's the specific provision, whereas Section 70 is a mere general saving provision in a proviso.
Same with evidence.
Second, the last words of Section 68 are made meaningless if you read Section 68 as being expanded by Section 70. I submit the whole point of the last words is that the certificate of title is taken as you're being seized of possession,
Yeah.
which is inconsistent with the notion, necessarily inconsistent with the notion that actually your rights are subject to an adverse
Well,
possession.
it's seized and possessed of such a state, i.e. a state subject to any easements, subject
Yes.
to any third tenancy of less than 3
Yes,
years,
yes.
subject to all the... And therefore, again, I come back to the boring scratch record point. Why not subject to everything that's in the proviso? Why only some?
Well, because, my lords, in itself, it doesn't say that. That's why. Because it talks of the subsequent operation. That's why, my lords. Essentially, that's what it comes down to.
Okay. Anyway, sorry, I'm repeating myself. Yes, thank you.
My lord, the third reason I say that Section 68 has primacy over Section 70 is the purpose of the Act. It's manifest, in my respectful submission, what the purpose of the Act is, and to impose on the purchaser the duty, especially in an island like Jamaica, to make the sort of extensive searches you might well have to make in order to discover adverse possessors, I submit does not facilitate conveyancing at all, especially when the adverse possessor himself can register his interest by way of caveat. And finally, the other provisions of the Act, which I took you to, I submit, are all premised on the certificate of title holder having a good title, which is not liable to be defeated by something which has happened to him before. When I say that, I mean the bona fide purchase of value. My lords, that's what I say in answer to what you might call the 3-year tenant point, as it affects Section 161. My lords, as it affects Section 163, I submit the point doesn't arise. When you go back to Section 163,
Yes.
this wouldn't prevent, in my respectful submission, this would not prevent the tenant bringing a claim for damages against the bona fide purchaser of value.
Damages, as aforesaid, brings you back to the opening words of 163, doesn't it?
Yes.
Or
But it wouldn't. But in my submission, the tenant could A, bring an action in damages, and he could also B, bring an action for specific performance or whatever, or injunction. He would be entitled to do that under Section 163 because the bona fide purchaser can only use 163 insofar as it concerns whether he took from someone who is properly registered or not. But that wouldn't help him, in my respectful submission, defeat a claim by a tenant for damages on the basis that he took subject to the tenant's claim. In other words, all Section 163 is doing is preserving the bona fide purchaser's estate on the basis that, well, even if there was something wrong in the even if there was something wrong in the vendor's estate, or even if there was something wrong in his title, that is not to affect the bona fide purchaser's title. But that wouldn't in itself defeat a claim by the 3-year tenant, or indeed any tenant.
because fraud and error don't come into it.
Yes.
Why do they come into it with adverse possession then?
Well, because...
if you're wrong so far.
Yes. In my submission, it comes in precisely because if I can put as a freeze the position at the moment that the vendor sells to my clients, as at that point, I submit the vendor, there is an error in the vendor's title.
That all goes, that comes back to that issue.
Yeah, it comes back. There's an error in this title, and therefore, when I don't realise the error's there.
I understand.
I take, and so on. I take free, therefore.
You say it's an error.
Vendor would be subject, but purchaser's not subject.
But it speaks of the person, the proprietor, may have been registered as a proprietor through fraud and error. So the wording naturally looks to the moment of registration, not what happens thereafter. And ditto, where one's derived it through a person registered as proprietor through fraud or error. You're having to read 163 as an error occurring after registration by virtue of adverse possession.
Yes. I'm reading it. I'm indeed. But the words of my respectful submission may have been registered as proprietor through fraud or error are wide enough to cover either A, the situation when the vendor got the registration through error, or when something has happened after his registration, but the registration becomes erroneous thereafter. May have been registered, as at what date are we talking about? As at the date registration took place, or as at the date of the transfer? My submission is wide enough to cover as at the date of the transfer. And one asks rhetorically, why should any distinction be drawn between the two situations? It's just as bad from the bona fide purchaser's point of view when the error occurs.
Yes,
I have of course, I have your lordship's point about the grammar, but in my submission, it's not conclusive. My lords, those are my submissions in relation to the proper construction. I'm very concerned about the time, my lords. We have made our submissions in relation to Chisholm and Hall. Perhaps I can just say what the three errors are in very short order. First, it does not consider the other provisions of the Act which I've taken you to. In particular, it doesn't refer to section 161 and 163.
that's right.
Second, in my submission, it wrongly gives far too much attention to section 88 and treats that as if that is the dominant or relevant provision. I've made my submissions on section 88 already. In my submission, it's not talking about this situation at all. And my lords, what I submit is important to note in section 88 is the phrase whilst continuing. All section 88 is directed towards is what happens to someone who takes over certain rights, for instance, under a lease. He is liable for the things while he is himself in possession, whilst continuing in possession.
Yep.
So section 88 in my submission has nothing to do with it, and certainly not as much as the other provisions. Thirdly, my lords, if you look at page 740 to 741, the reason why the board rejected,
page 1438 to 1439, yes.
Yes. Essentially, my lords, what happens there is that the board rejects the replacement certificate argument. The main argument was the replacement certificate argument, which was obviously a hopeless argument. And it rejects that argument at page... I'm reading internally.
Don't worry, it's fine, doesn't matter.
Yes, it's the third paragraph down. At all events, their lordship's construction of section 69 has the merit of consistency.
Right, it's page...
I've got it in page 518 as attached to our case, my lords. I think it's also in volume...
Which page is it in the report?
740.
Thank you. At all events, I have it. Thank you.
At all events. And this is
1437, yeah.
And this is a line of reasoning which I submit is manifestly unsatisfactory, with the greatest respect to the board at that time. At all events, their lordship's construction of sections 67 and 69 has the merit of consistency, and avoids the anomalous and absurd results which would ensue from the adoption of the construction which the plaintiff seeks to place upon the two sections. On that construction, a man could acquire title registered land by 12 years' possession, and having done so, enforced against the registered proprietor, although no note was on the register, provided that no new certificate had been issued since his title by limitation was acquired. But the issue of a new certificate, in whatever circumstance and for whatever reason, would destroy a complete title by limitation after being acquired. And it goes on, therefore, at that point, as it were, to repeat or rehash a hopeless argument. The hopeless argument was being advanced. And obviously the mere fact that I get a replacement certificate can't bring in play section 68 for the reasons which the board here gives. But that's not the point in the case. The real point in the case is, given you've got section 68 and section 70 and the purpose of the Act, to which should you give primacy? Looking at all the other sections
overruling of Goodison was obiter in some
No, I don't-
curious way?
No, my lord, I don't think I can. Well, no, I don't think I can say it was overdone. My lord, they overruled Goodison, which had effectively held that Section 60. Not sure they actually put it this way, but effectively gave primacy to Section 68 over Section 70. I agree with that. But the problem with this is that the reason they're doing it is because they're doing it on the back of an argument which is manifestly hopeless. And they're not really turning their minds to what I submit had to be considered, namely all the protections given to the bona fide purchase of a value and the evident intention of the Act.
Yes, but we also have to look at what is said at the bottom of 739 and top of 740, because the passage you're founding on starts in all events, but the reasoning is their construction of what is now Section 70.
Yes. Indeed, my lord. Yes, I accept that. My lords, I just say that is wrong.
Yes, quite.
I don't think I can say much more about it.
Can you just deal with my point of view, if you have anything you want to add? That if we have, as might be said to be supported by some of what you said this morning, a statute which is not terribly well drafted, where one might conclude that you could reach two different conclusions, that for which you argue and that for which the respondents argue. If one of them has been the subject of a careful decision of the Judicial Committee given nearly 60 years ago, and the legislature has had every opportunity to amend the legislation, indeed have done so, that we should not now undo a decision which has been so long-standing and has been so clear.
Well, my lords, I would accept if the point is totally ambiguous either way. I think I'd have to accept the usual rule is you stand by previous decisions in the interest of certainty in the law. There are, however, points I would want to make against that. In my respectful submission, the result of Chisholm and Hall is productive of two things. First, great injustice. I respectfully submit it's very difficult to see why a man who's paid out his money should lose to a man who's paid nothing in relation to a plot and taken no steps to protect his interests. On the face of it, that's an unjust result. I don't shrink from saying it.
Okay, well, you've said it. Yep, thank you.
And it's not clearly, and it's inconsistent with the, on the face of it, manifest purpose of the statute, but also, my submission, it is productive of inconvenience in conveyancing. It complicates conveyancing no end.
The Parliament hasn't, the legislature hasn't seen fit to reverse it.
The legislature hasn't reversed it, but, my lords, I say that's not conclusive. That could be said of any case. I mean, obviously, I accept there's a point against, but in my submission, not conclusive.
I understand.
And I do also make this point. To reverse Chisholm and Hall would not upset any established titles. In real life, it's difficult to see how it would. This is not like a case where a court, as it were, decides to give a different interpretation to a well-established phrase in an insurance contract, which people have been working on for a long time. It's quite the opposite. It's the opposite end of the spectrum. So I do submit that, my lords, if, let's say, your lordships were to find on balance that our submissions were to be preferred, having considered everything, then I submit, even if, in those circumstances, I submit the usual reasons for not changing the law, or the usual reasons for keeping to a precedent, don't apply with the same force as they would in other cases.
Understand.
My lords, I know Dr. Barnett would like to add one or two points, but I'm also conscious of the time.
Well, perhaps you'd better do so very quickly.
I'm obliged. My lord, unless there's anything else.
No, thank you very much, Mr. Knox. You have overrun, but we have asked you a lot of questions. Dr. Barnett.
Please, Your Lords. May I begin by answering a question which my Lord Wilson asked in relation to the ability of the adverse possessor to apply for registration when he has ceased to be in possession. Under the provisions of Section 85.
85.
Yes, madam. Which is at 775.
Thank you. Yes, we've seen that. That's the one Lord Wilson was asking about.
The question related to whether if he's out of possession.
He's acquired. I think we'd accept that once he's acquired a title, he's entitled to apply.
Yes, my lord, but not using this new section which was put in, and that's for the reasons that the terms of the section, if you look at 85.
Yes?
where it says he may apply to the registrar.
Yes,
And the application has to be in accordance with 86.
yes,
And that provides in subsection 2
yes,
that it shall apply mutatis mutandis in relation to an application under
yes,
section 85 as they apply in relation to an application to have the land brought under the operation of the law.
yes,
And under the provisions relating to bringing the land under the operation of the law, sections 31 to 36,
yes,
which are at page
Point is that he
751.
is in possession.
Yeah.
He has to be in possession.
Yes, 31.
Yes, sir.
he doesn't have to be in occupation, he has to be in possession, yes, I see. Yes,
The second point I would wish to make is that there is a possible rational alternative for resolving the clash between section 68 and section 70. And that is because in section 70, before the proviso commences, the main provisions of section 70 deals with cases of wrong description of parcels or boundaries, which are included in a certificate or instrument. And in respect of that situation, exempts or excludes a purchase of a valuable consideration or someone deriving from such a purchase.
which section?
This is on page 769.
Thank you. 769.
769.
Thank you.
If therefore in a situation involving a misdescription of boundaries or the inclusion wrongfully of parcels of land, the bona fide purchase of a value is excluded from the operation.
This is
Of the-
section, which section?
This is in section 70, my lord.
70.
Yes,
Sorry.
immediately before the proviso.
It's in the proviso, I see now.
If
Thank
you read the
70.
last 5 lines, immediately before the proviso. If as is apparent, it excludes the purchase of a value,
Yes.
it means therefore that the proviso in those circumstances become inapplicable to the purchase of a value, and there is no inevitable clash between the provisions of the proviso in relation to possessory title and the provisions of section 68, which gives conclusive evidence of the right of the proprietor, subject only to subsequent operations of any statute of limitation.
Thank you.
And so it is possible, therefore, to avoid the conflict between the terms of the application of the statute of limitations in the proviso and its terms in section 68.
Sorry, I haven't, I think, followed this point. The argument is that what the proviso doesn't apply to situations where there's a purchase of a value.
Yes, my lord. Because,
Why not? It's a general proviso.
so because these lines which I asked you to read to the end of the main section of section 70 excludes from its operation in respect of wrong description of parcels or boundaries,
Means that
a purchase for
means
value.
that the purchase of a value would take free of easements, yes?
Yes, my lord.
I see. Okay, thank you.
And therefore the conflict which Lord Jennings apprehended in Chisholm and Hall could be resolved in that way without undermining the main objectives and purposes of the registration of title system. From a practical point of view, also, the construction for which we advocate avoids the impracticability of the alternative approach. And to give three quick illustrations, where the owner of a vast tract of land in rocky and mountainous terrain sells to B, B may visit the land several times before signing the agreement. And even if he spends several hours on each visit, he may fail to observe a squatter who, if present at the time of the visit, is in small enclaves on the land.
I think we have that point, Dr. Barnett. Yes.
Yes. There is also the situation in which an adverse possessor might have left the land several years before the issue arises, but he had accumulated his 12 years.
Yeah, again, I think Mr. Knox has made that point, that this would work unfairly to a purchaser who may not be aware, even if he inspects the land, that a person who's absent has acquired.
I'm making the point, my lord, because of the suggestion which was made that the purchaser could, by inspecting the land over a reasonable period, obtain information. I'm saying that the relevant information might be 6 or 7 years before the purchase.
Yes, I mean, yes, your point is that even if a purchaser bought the land and then occupied it until they had occupation for 12 years, they'd be vulnerable to a claim of adverse possession.
Indeed, my lord. Because if the 12 years has accumulated and 6 years have passed, the adverse possessor is still entitled. But in that 6 years which have passed, there is no evidence on which the purchaser who visits would be able to ascertain the existence of that adverse possessor. So on those bases, my lord, I would enjoy it, asking that the appeal be allowed.
I'm sorry, I misunderstood the point you were making. Thank you. Thank you very much. Good. We will consider where we've got to, and we'll rise now and return shortly. Thank you very much. Court's now adjourned for 5 minutes or so. Mr. Knox, Dr. Bonnet, we're very grateful for your submissions, and they were, if I may say so, very well put, but I'm afraid we're not persuaded. In those circumstances, Mr. Wood, we don't have to trouble you.
A pleasure.
We will give our judgment in due course, and in due course we will we'll take time to consider what advice we will humbly tender to Her Majesty. Thank you very much. The court's now adjourned.